Welcome back to the Law on Partnerships and Private Corporations. To continue our discussion, let's go to Article 1770 of the Civil Code, which essentially tells us for what purpose can we put up a partnership. Article 1770 tells us that a partnership must have a lawful object or purpose, giving us the idea that basically, partners can decide to put up a partnership for whatever purpose that they want or they need, so long as that particular purpose is lawful. And again, the qualification is that they must also be for the common benefit or interest of the partners. So again, to emphasize, the purpose of the partnership must be lawful. And also, going back to Article 1767, it specifically tells us that two or more persons may form a partnership for the exercise of a profession. So again, exercise of the profession is a purpose specifically granted, or a purpose specifically stated, or a purpose that is specifically allowed under Article 1770 of the Civil Code. Now, first question that we ought to discuss: may a partnership be formed, or may a partnership be established for the exercise of a customs broker's profession? Well, Article 1767 of the Civil Code expressly states that a partnership may be formed for the exercise of a profession. So the answer is yes. A partnership may be formed for the purpose of exercise of the customs broker's profession. Now, second question: assuming that a partnership was indeed formed for the purpose of exercising the customs broker's profession, is the partnership then engaged in the practice of the customs broker's profession? Now, take note that earlier we have discussed that a partnership has a personality separate from that of the partners. Again, a partnership is a separate juridical entity which has a separate and distinct personality from the personality of the partners. We also take note, second, that Republic Act number 9280, specifically Section 28 thereof, requires that before a person can practice customs broker's profession, he or she must pass the licensure exams, and he or she must also be a holder of the certificate of registration and ID card or permit. Now, given these requirements, it is reasonable to conclude that these requirements can only be met by a natural person and not by a juridical entity like a partnership, because logic would dictate that a partnership cannot review for and take the board exams for customs brokers. And again, we go back to the concept of separate juridical entity, emphasizing that the personality of the partnership is different from that of the partners. So what's the relationship then if the partnership has been formed for the exercise of the customs broker's profession? Well, my personal opinion is that even if a partnership is formed for the exercise of the customs broker's profession, it is still the individual partners who are exercising their respective professions and not the partnership itself. Again, I think that, or I am of the opinion that, even if a partnership is formed for the purpose of exercising the customs broker's profession, it is still the individual partners practicing their professions and not the partnership itself. In relation to this, I think we must discuss also this case of Acevedo Optical Company Incorporated versus Court of Appeals. This is a case decided by the Supreme Court in the year 2000, and the important portion of the Supreme Court's decision distinguished a license to do business and a license to practice or to engage in the practice of a particular profession. The Supreme Court explained that a license to do business is different from a license to engage in a particular profession. First of all, a license to do business is issued generally by the local government or by the local executives, and on the other hand, a license to engage in a particular profession is within the jurisdiction of the respective professional regulatory board of that particular profession. Moreover, they seek to regulate two different things. One seeks to regulate the conduct of business, and the other one seeks to regulate the practice of the profession. The Supreme Court, in its decision in this particular case, also stated that the employment of a qualified optometrist by a corporation is not against public policy. So in other words, the Supreme Court seemed to state that a professional may be employed by a corporation, and in this case, even by a partnership, and in that instance, it is still the natural person or the professional himself or herself who exercises his or her profession, and not the corporation or the partnership which employs him or her. So again, the distinction has been set between the professional and the business which employs him or her. It is still the professional or the natural person who remains to exercise the profession, and not the partnership or the corporation which employs him or her. The court also noted by analogy that several private hospitals have been or are being operated by corporations, yet these private corporations have never been considered to be engaged in the practice of medicine. The prevalent practice is that doctors are being employed by these corporations owning the hospitals, and these doctors remain to be the ones practicing their respective professions. The doctors are the one engaged in the practice of the profession, and not the corporation which operates the hospitals themselves. Now, next question for our discussion. In the event that a partnership is formed for the exercise of the customs broker's profession, can that partnership admit as partner someone who is not a customs broker? In other words, may a non-customs broker be admitted as a partner in a partnership engaged for the exercise of the customs broker's profession? First, we consider the Code of Ethics for Customs Brokers, which expressly states that a person or a customs broker, he or she, shall not be a party to any plan which would permit any person not registered in good standing with the Board of Customs Brokers and the PRC to practice as a customs broker. Now, if a partnership is formed to engage in the customs broker's profession, if they admit a partner who is not a customs broker, is that tantamount to allowing a non-customs broker to practice the customs broker's profession? Is it a violation of this provision of the Code of Ethics? Well, my personal opinion is that a partnership formed to engage in the practice of customs broker's profession may admit as a partner someone who is not necessarily a customs broker, so long as the partnership employs someone who is a licensed customs broker. Why so? First and foremost, there is no prohibition for such arrangement. Second, take note our discussion earlier based on the Acevedo case that in such instances, it is still the individual professionals themselves who are engaged in the practice of their respective professions, and not necessarily the partnership or the corporation itself. Next reasoning would be, the law also allows a corporation to engage in the business of customs brokerage so long as it has in its employ a licensed customs broker. So by way of analogy, I think a partnership can also do so, can engage in the exercise of the customs broker's profession, admit someone who is not a customs broker as a partner, so long as it has someone as a partner who is a licensed customs broker. We also take note that a partnership is formed by an agreement between persons to contribute money, property, or industry. In this instance, a person may be considered as a partner even if he or she does not necessarily contribute industry. He may instead or she may instead contribute money, or he or she may instead contribute property and not necessarily industry. So there is really no impediment for me, for someone who is not a customs broker, to be a partner in a partnership established for the exercise of the customs broker's profession. Again, with the caveat that the functions of a customs broker reserved to a customs broker should still be performed by someone who is licensed as a customs broker.